checking with my clerk whether this time I have got everything I need.
You haven't forgotten the judgment.
I've got the judgment. I have to call Rundle. I think we're all right. Yes. Carry on.
Thank you, my lord. I've dealt.
Oh, actually, may I just mention one thing before you start? I think it would probably help us, though in the end it may not matter very much, but I think it would help us to have a copy of the AMPOC showing the amendments. Presumably, I've got out of touch now with KB procedure, although I think once amendments have been, people work on a clean copy. Nevertheless, there has to be a copy that shows the amendments.
Yes.
Presumably, if you could get that out and send it to us.
We will.
Thank you.
We had a whole lever arch file of earlier versions.
I think we only, I'm sure we don't want to have anything more than the actual version for which permission was given.
There is a colour version of the APOC as
better
approved.
Still.
Lords, I've dealt with the first feature of the proceedings below, which was the pre-trial stage. Can I turn to the second, which is the trial?
Yes.
In paragraph 3 of our skeleton, perhaps just for the court's notes, don't need to look it up, we briefly describe the trial, and it's relevant, we submit, in terms of putting the judgment and the criticisms of the judgment into context. The trial lasted 18 days, excluding hand-down and consequential arguments. There were 11 factual and 4 expert witnesses, all of whom were cross-examined. The documentary evidence was voluminous. There were 12 volumes of chronological documents comprising over 7,000 pages, 5 volumes of documents consisting of experts' reports and the documents exhibited to their reports, and a further lever arch file of documents exhibited to the APOC, which comprised 633 pages. There were written opening and closing arguments. The parties were afforded time after the end of the evidence to prepare and exchange written closings, which ran to 296 pages in total. There was a limit of 150 per party, followed by 2 days of oral closing submissions, 6 lever arch files of authorities and other legal materials. And to make an obvious point of the whole sea of evidence that was before the trial judge, the documents before this court comprise only a few islands, to use Lord Justice Lewison's language. Lords, that's all I propose to say about the trial. Thirdly, the judgment. And may we just draw attention to certain features of the judgment. Of course, the structure of it is clearly laid out in pages 86 to 90 at the start of the judgment. Can I just draw the court's attention to paras 41 to 42, starting at page 101, the heading, the revocation of Mr. Benyatov's FCA authorization, just so the court understands what led to that. Following the first conviction in December 2013, the bank, as one would expect, notified the FCA of the conviction. The FCA's response is referred to at para 41. And then we see from 42, the FCA asked the bank what role, if any, Mr. Benyatov was then performing. And as your lordships will appreciate, he wasn't performing any by that stage by reason of the redundancy consultation. So he'd been put at risk of redundancy in October 2013. But the bank, as the court I think has heard, kept him on the payroll until some time after the appeal judgment in January 2015. The bank says in order to show its support for him, Mr. Benyatov at trial said it was linked to evidence that he gave in another unrelated case, and the judge refers to those contentions at para 45. But it was the bank that then submitted the file C to the FCA, notifying the FCA that Mr. Benyatov was no longer performing any regulated role. And so it's not quite as simple as to say the FCA terminated his authorization because of the conviction. The circumstances giving rise to it are those set out in 41 and 42, and the register of the FCA simply says regulatory approval no longer required, no disciplinary or regulatory action taken, and so on.
That's important to the interests of accuracy, but are you hinting or saying that the reality is that as long as the conviction stands, he could not be readmitted? I appreciate you can't speak for the FCA, but I suspect your clients know a lot about how they work. Could not in practice be re-registered?
Well, I'm not seeking to make a point about that, although I'm just concerned that the court has this picture clearly. And of course, in terms of FCA authorization, in our submission, it's a bit of a non-issue because, firstly, Mr. Benyatov is living in the United States of America. Secondly, his authorization was brought to an end because he was effectively no longer performing regulated role, and he was then made redundant. Of course, in the future, were he to seek a job, then he would need to apply for the job and then seek any appropriate regulatory approval. And I'm not taking this matter any further.
No, I understand that. And of course, we're not concerned with the quantum. But at the moment, I see force in the reality of the situation as presented by Mr. Chumé. This is only relevant perhaps for background purposes, but that as long as the conviction stands, potential employers are unlikely to want to be, for controlled work, are unlikely to want to apply to the FCA, partly because even if they do, they think it's unlikely registration will be granted.
If the FCA was the appropriate regulator.
Yes,
yes,
whoever that would apply to other regulators as well. That seems a realistic approach.
Well, I see the force of that point. There's maybe a slight inconsistency in saying this is such an outrageously wrongful conviction, and yet it's such a conviction that it should stop.
Yeah, but the point is the regulator can't get involved in going behind it. Or they could, but you can see it would be a major thing for it to do. And
yes, I see the force of that. As I say, I'm not seeking to make any further point than just ensuring the court understands what the circumstances were that led to.
Just while we're on that, I suppose a possibility is that a regulator might be more willing to look sympathetically at it if the European Court of Human Rights had themselves, while they couldn't quash the conviction, said some disobliging things about it.
That may well be so.
But you don't know any more than Mr. Chumé about what's happening about that application. Are your clients still involved in supporting it in principle?
They're still funding it. Clifford Chance are acting for Mr. Benyatov. I think there's some perhaps slightly ambiguous references have been made to whether Clifford Chance, as the bank's lawyers, have made the application. Clifford Chance were jointly instructed by the bank and Mr. Benyatov.
Yep.
The bank are paying. Clifford Chance have lodged the application on his behalf. I was going to mention that there was placed before the trial judge some recent correspondence between the court, the European Court of Human Rights, and Clifford Chance as Mr. Benyatov's lawyers, with the judge rapporteur asking certain questions regarding whether Mr. Benyatov's Romanian lawyers had a certificate, or if not, had applied for a certificate to have access to evidence that was before the Romanian court that was otherwise subject to state security classification.
I see.
So
but all that shows is that it isn't completely dormant. Or
it's not dormant, and that correspondence was in, I think, April of last year, with a reply by Clifford Chance on behalf of Mr. Benyatov.
It's just useful for us to write off with the sort of thing one might want to put in the introductory sections of a judgment, but it's not otherwise important.
Yes.
No, thank you very much.
And as matters stand, presumably, Mr. Benyatov, if he sets foot in Europe, is liable to arrest under a European arrest warrant, isn't he?
Well, that's what he has said, and I'm not in a position to dispute that. That's, I think, why he is based in America and gave evidence from there.
I mean, it's a curiosity of the case that although he was in fact arrested on a visit to Romania, proceedings with ultimately the same consequences could have been started against him, even if he'd never been to Romania at all.
Indeed.
Managing everything from London.
Absolutely, my lord. And the judge makes this point on a number of occasions in the judgment with respect to Mr. Flore, who was one of the other two Credit Suisse employees, still an existing employee at the time that Mr. Benyatov was arrested. Mr. Flore had not gone to Romania with Mr. Benyatov in November 2006, but yet he was indicted and convicted.
Yes, I know. In fact, presumably having some sort of assurances he wouldn't be reincarcerated, we're told that the Mr. Benyatov did, following his release, go back on more than one occasion to Romania in connection with the proceedings against him.
Yes.
Did he actually? Was there anything we would recognise as a trial at which he gave evidence?
My understanding is that there was a trial, but he didn't give evidence.
Yes,
and I think what is said on his behalf is he was not given the opportunity.
Yes, I see.
Or permitted to give evidence. But my lord's,
I'm sorry, I probably should.
my lord's point about the significance of him being there or not is, with respect, well made, because Mr. Flore, as the judge says, didn't travel, and yet he was still convicted. So a simple suggestion that if Mr. Benyatov had not gone to Romania, it would all have been different. That doesn't follow. Lord, I was just going to highlight some features of the judgment, if I may. And on this point, the judge was clear that both claims, the negligence and indemnity claims, were fact-specific and failed on the facts. Could I just give some references to that? Starting at para 50 on page 103, we see the judge identifying 5 factors which were, he said, at the core of the case.
So which page? Which paragraph?
103, para 50.
Yeah.
And perhaps for your lordship's notes, by way of cross-reference, we can see that the judge, in his conclusory section, deals with item 1 at para 2261, item 2 at 2262, item 3 at 2264, item 4 at 2263 and 4, and item 5 at section 8. So having
226, 4, 3 he deals with at 4.
Yeah.
4 he deals with at...
A mixture of 3 and 4. So subparas 3 and
Got
4
it,
of
yeah.
226. And then 5 at section 8
Yeah, thank you.
of the judgment.
And should we just note subparagraph 4? The way he expresses the knowledge issue there.
Yes, well, had or ought to have had.
Indeed.
Yes. And one sees this throughout, that he uses the language of reasonably should have foreseen. So he was clearly applying, we say, an objective approach throughout. And then in section 5 of the judgment, which begins at page 118, paras 104 to 111, the judge identifies the appellant's case as to duty of care. At 104, he refers to the pleaded case in the APOC at para 24. The judge calls it the AMPOC, but we see that reference at the very end of 104. So he's got that in mind. Then at para 105, importantly, the judge says, in pleading such duties, Mr. Benyatov relies on a large number of circumstances pleaded in para 25. All of the circumstances have been considered. At 106, over the page, he identifies the basis of Mr. Benyatov's case. Including the flags, but other matters as well. And then it's at 107 to 111 that he refers to a number of places to it being fact-intensive. So 107, penultimate line, there's a common factual substratum to justify both scope of duty of care and indemnity. 106, it's therefore a fact-intensive duty of care and duty to indemnify. And at the end of that paragraph, last sentence, now for the court to determine whether on the facts of this case there is such a duty. At 109, halfway down the paragraph, just after the reference to AMPOC para 25, given the specificity of the duty to the facts of this case, it's necessary to be cautious about a floodgates argument. At 110, last sentence of para 110 over the page, the question then might be not whether such a duty could not arise, but whether it arises on the facts of the instant case. 111. So it's for the court to make factual findings relevant to what is a fact-specific duty of care. As we see, the judge then considers the law on duty of care at section 6, between pages 121 and 133, and it's towards the end of that section, on page 133, at para 154, that having considered the law in dealing with the application to the instant case at 154, second line, or perhaps reading from the beginning, in a novel case, the question whether there's a duty is not to be decided subject to general parameters. It's very fact-sensitive in each case. 155, second line, at the end of the second line, in each case, it will depend upon a consideration of the precise facts, the foreseeability of the particular harm, and whether in all the circumstances it's fair, just, and reasonable. And one recognises, of course, those two elements from the three factors identified in Caparo and Dickman, which were proximity, reasonable foreseeability, and is it fair, just, and reasonable to impose a duty. And at 156, the judge again notes it's for this reason that at the heart of the case is para 25 of AMPOC. And one sees what he then says, and the last sentence in particular, fact sensitive, and it's to the facts that he then turns. And he deals with the facts in section 7, paragraphs 157 to 223, 21 pages of the judgment. He makes findings of fact. At 166 is again a number of factors listed by way of overview. And having then dealt with each of those factors, high-risk country, high-risk transactions, warning flags, and then risk assessment being not standard, the judge, and features specific to Mr. Benyatov, the judge deals with his conclusions at page 153. And again, it's important to note in our submission how he approaches this. 224, key features relied on by Mr. Benyatov have not been established. 225, second sentence, having reviewed the entirety of para 25A of the AMPOC. He said, I think, 25A there because that was previously the numbering used, but he's referring to 25. So having reviewed the entirety, unable to prove the basis, and so on. And we see the key findings then at 226. 227, therefore, fails by reference to the facts of the case, the first sentence. And the judge then, for completeness, dealt with some other defences we had advanced, as we see at the end of 227, not strictly necessary, but he dealt with them anyway. And it's perhaps worth noting in that next section at page 157, under the heading C, responsibility for risk, the judge finds that Mr. Benyatov did have some responsibility for risk. So the last sentence of 241, it was reasonable to expect of him in the first instance, where appropriate, to escalate matters to LCD, that's Legal and Compliance Department, and others involved in the assessment of risk. 243, again, on the same topic of Mr. Benyatov's responsibility, fourth line, if there was a situation which required escalation, it was for him to refer it.
Which para are we on there?
243, my lord,
Yeah.
fourth line down. Next line, thus in respect of so-called warning flags, to the extent that he chose not to refer matters such as the last three flags, the matter would generally stay there. Last sentence of that same paragraph, when it came to points which arose in the course of the project, such as being called warning flags, there was reasonably a responsibility on the part of managing directors, where appropriate, to bring these matters to the attention of LCD. Mr. Benyatov, of course, was a managing director. And 244, the fact that Mr. Benyatov did not escalate them is evidence at the time that on the information available, they were reasonably not perceived as warning flags. And then he has another conclusory paragraph at 245, having considered those additional defences advanced by the bank, which didn't strictly arise. He again states his conclusion, major building blocks not established. And interestingly, in this paragraph, he goes on to say, halfway down, absent all of this, and having considered the evidence as a whole, in my judgment, the conviction and subsequent losses were not reasonably foreseeable. Further, in circumstances where there was so much business activity in Romania, and against the background of successful privatisation work undertaken by the bank involving Mr. Benyatov in the early years of the decade, it was not fair, just and reasonable to create the alleged or a related duty of care. So he addresses both of those limbs, if you like, of the Caparo test. No reasonable foreseeability of loss, and it was not fair, just, and reasonable to create or impose the alleged duty.
That particular part of his reasoning, I suspect if one understood the submissions before him, it would be clear, but it doesn't leap from the page why the fact there was so much business activity in Romania and why previous work undertaken by the bank had been successful makes it not fair, just, and reasonable to create the duty of care. What's the thinking behind those?
Well, on the first of those two, there was extensive evidence that of how much business was being conducted in Romania by foreign companies, particularly investment banks in the privatisation exercise, that was being encouraged specifically by the UK government as far as British-based businesses were concerned. And the bank was part of that trend, if you like, of overseas investment banks.
So why does that go to the question of whether it's reasonable to carry out risk assessments?
Well, the other businesses, the evidence was, did not carry out risk assessments. The judge found not only that risk assessments were not standard, but that it was standard.
It plugs into that point.
It was standard that there were not risk assessments. For example, Mr. Quayle said at the British Embassy, nobody ever approached him with questions about, well, is it a risky place to do business? The experts said they didn't know of anybody that carried out a risk assessment in relation to doing business in Romania at the time. So I think what the judge is saying there is that where other businesses were going to Romania and not carrying out risk assessments, it wouldn't be fair, just, and reasonable to impose a duty on Credit Suisse to carry out a risk assessment. And in relation to the second point he mentions, there have been a significant number of earlier privatizations on which Mr. Benyatov had worked in Romania in relation to energy utilities, acting both for the Romanian government and previously for Enel, who was the successful bidder on the EMS transaction, with no difficulty having arisen in relation to any of that previous business. And I think the judge is saying, well, against that background, it would not be fair and just and reasonable to require the bank to carry out a risk assessment in relation to the EMS transaction, because there was already a long track record of successful business without anything untoward having taken place.
Yep, thank you.
And then just finally, my lords, in terms of the judgment, later in the judgment, when the judge deals with the indemnity in fact, he again returns to the factual findings, and the court saw this briefly yesterday. It's really page 189 of the judgment, starting at 359, under the heading indemnity in fact. And one sees, just to highlight one or two sentences in this section, at the end of para 362, having reviewed the evidence and the findings of fact, the judge says it follows that the substratum of the alleged indemnity is not made out. Again at 365, third line, the basis sought for such a finding is not made out on the facts of the case. A finding that there's an indemnity in fact. And the last sentence of 365, this claim failed on the facts. So in our submission, what's abundantly clear from these passages and reading the judgment as a whole is the judge addressed his mind to the pleaded basis for the alleged duty of care and indemnity and made clear findings rejecting the factual basis of the claim.
Mr. Goulding, I don't know whether you were going to go back to it, but you skipped over the section of the judgment which deals with breach of duty of care.
Did, my lord.
It begins at page 158 at paragraph 246.
Thank you.
In a nutshell, have I understood that section of the judgment correctly, that having considered the evidence, the judge concludes, as a matter of fact, that there were no breaches?
Yes, my lord, that is right. The judge, and thank you for drawing my attention to it, the judge, having found there was no duty, went on to consider, well, if he's wrong on that and there was a duty, was there a breach of it? And finds in clear terms that there was no breach.
But am I right? I mean, it's clear he doesn't regard the one as complete, his reasoning on no duty as completely transferable to no breach, because he addresses various points. But this is the class of case, isn't it, where the question of whether there's a duty and the question of whether, if there was a duty, it was breached, overlap very considerably and depend very considerably on the same facts.
There's an overlap, my lord, I accept that. Whether they overlap very considerably, I'm not so sure I would accept that. They are distinct questions.
They're certainly conceptually distinct.
Yes.
Get that.
Yes, and he does address some different issues under breach than he addressed under
Yes, I see that too.
duty. So under the risk assessment section beginning at 249, he does talk about the various committees that existed and how they were operated within the bank. So I think it's right to say that they stand as distinct findings by the judge.
No, certainly.
And it's certainly our submission, and I will come to this when we deal with the negligence grounds, that the appellant needs to succeed if he's to win on appeal, not only on ground 3 in any event, the limitation ground, but he needs to then succeed on duty and breach.
Yes. The point I was making wasn't just me. I mean, it's very much, the judge makes it himself at the very start of
Yes. Yes, he does. Well, that's right. He recognises there's that overlap. So, my lords, that was what I proposed to say just by way of observations on the proceedings below. Turning to the individual grounds of appeal, in oral or closing submissions before the trial judge, the parties both dealt with negligence first and then indemnity. And it seemed to us, at least, there was a logic in doing that, not only because so many of the facts were relevant to the negligence claim, but when considering the indemnity claim, it was sensible to do so against the backdrop of the duty of care claim.
So I don't think this matters, but Mr. Chume, I think, told us that he put indemnity at the forefront of his case below, but that's not
how the matter was dealt with in oral submissions.
Right.
We dealt with negligence first, then indemnity, both of us. And we say, in short, if having considered all the facts, the court is of the view that there's no duty of care to prevent particular losses, against that background, it would be a remarkable conclusion to say that nevertheless there's a strict liability under the indemnity to compensate for those losses. But that's merely a structural question. Which goes first? Of course, you've got the grounds of appeal which deal with negligence first and indemnity. But what I was proposing to do, unless the court would like me to do it differently, is follow Mr. Chume's approach, just because that's the order in which he has dealt with.
No,
I
take the point about your structural point, but frankly it doesn't matter to us in which order they're presented. If that's how you prepared it, by all means do it that way.
Well, let me then turn, if I may, to ground 4, the indemnity in law ground. And what I propose to do here is first consider the judge's approach to this question, because we say the judge was correct in his approach, and second, to address the appellant's criticisms of the judge's conclusion. Firstly, the judge's approach. There are 4 distinct steps, we say, in how the judge approached the indemnity in law claim. Step 1 begins at para 305, which is where the judge addressed the test for the implication of a term as a matter of law. Your Lordship has already referred to the well-known phrases, one from Scally. For the term to be implied in law, this is the 3rd line down in para 305, it must be demonstrated that it is a necessary incident of a definable category of contractual relationship. And then the passage from Chitty, which is now in the 34th edition. He quotes from the 33rd, it's the 34th, it's the 34th you've got in the bundle. A term implied in law is implied as a general rule in all contracts of a certain type, or as a standardized term into a definable category of contractual relationship. And then at the end of that excerpt, focus is on the appropriateness of the term for implication into all contracts of the type that's before the court. So that's the test. Is it a necessary incident? Is it appropriate for implication into all contracts of the type before the court, which we say is all employment contracts? And there's no criticism, as we understand it, of the judge's direction as to the appropriate test. Step 2 begins at para 308, where the judge analysed the indemnity which as a matter of law is implied into contracts of employment. And he considered, firstly at 308, some of the commentaries, which I'll return to, as set out in the deputy judge's judgment.
Sorry, what was your heading for what he was doing at the second stage?
It's analysing the indemnity.
I see, exactly.
So
as
step
per,
one
as
was,
per his heading, yeah.
Yeah. Step 1 is the test. Now at step 2 is the analysis
Yep.
of the commentaries, then the case, some of the case law at 309 to 314, and the parties' arguments at 315 to 321. And his discussion then begins at 322. And that led him, importantly, we say, to a conclusion or finding at para 326 on this point, which is where he identifies 2 features. And so if one looks at para 326 in the middle, in my judgment, the features relied upon by the bank are powerful in indicating loss of earnings are irrecoverable as a matter of law in the implied indemnity. The features are at least twofold. And one is the absence of authority, in which losses other than sums paid or payable are recoverable, and the second is the Whitlam reasoning. Now, on the case law, the first of those features, if I can just make some comments on this and how the judge approached it, one sees at para 319, just turning back a few pages, that the judge referred to our submission about there not being a single case, and so on. The court sees what is written at 319. And he says the bank referred in its written closing to authorities, which Mr. Benyatov relies on. And the judge says, importantly, despite loss of earnings being common between employee and employer, none of the authorities are ones where lost earnings have been claimed or recovered pursuant to the indemnity. So it's not.
Where are we now reading from?
We're at 319, or para 319, in the penultimate sentence, despite loss of earnings being common. Lord, right.
Yes,
I'm so sorry. I should have said right at the start of 319. It's page 175.
Before the quote from your submission.
Yes. So it's not simply a matter of, well, there isn't an authority in favour of it, but in circumstances where lost earnings are a common claim made by employees to employers, one notes that never has lost earnings been apparently claimed or recovered according to the case law. And what the judge then does, as the court sees, is sets out our summary of the 11 authorities which we understood were relied on by the appellant as showing the indemnity. And on our analysis, all of them concern payments made or for which the employee or agent was liable.
Yes, now we've seen all of those except, I think, Lacey and Hill and Coulson.
Lacey and Hill and Coulson.
Number 5 and
Yes.
number 10.
Yes.
But
Well, my lord,
what we see from this, what you say about each of the ones,
Lord, I don't really
you don't
want
to
to
take
add
us back
to
to
that.
those authorities.
The court has it there.
Yeah.
Lacey and Hill, for the court's note, is in volume A1 at tab 8. What's interesting, if I may just say about Lacey and Hill, is this an example of where the indemnity covered a liability to pay, where the payment had not yet been made.
Yes.
That was a case of stockbrokers who had entered into contracts to buy stock on behalf of a Mr. Crowley, who unfortunately took his own life because of what happened in the stock exchange before the stock was bought. So the stockbrokers were liable to make payments pursuant to the contracts to buy the stock, and they claimed against his estate in relation to that liability to pay. And there are some dicta in the case that make clear that the indemnity covers a liability to pay, even where the payment has not yet been made. So it's an interesting example of that sort of application of the indemnity.
Sorry, I didn't want to interrupt.
No, not at all. No.
If you finish that.
I have, thank you.
Again, please don't take us out of order, but at some point it would be helpful, at least to me, if you could respond to Mr. Chumei's submissions yesterday about the Thagona and ENE costs, because he says that when you look at the facts of those cases, there were claims for loss of earnings.
Yes. Right, I'm certainly planning to do that, and I'm happy to do it now.
No, don't take it out of order, please.
In which case, I'll come to it more in due course, certainly. Thank you. And if one then looks at 336 of the judgment on page 184, the judge makes perhaps a similar point to the one we noted in 319 a moment ago. The last two sentences. From the researches of counsel, the imposition of an indemnity for loss of earnings has no precedent. It's not an answer to say that nor does the rejection of such a case have a precedent, since claims for losses of earnings are so common in tort cases. The judge is really saying, you know, if the indemnity covers it, you'd expect to see it claimed. And it's really too remarkable to think that generations of lawyers and judges have overlooked the availability of this indemnity remedy in loss of earnings cases. So that's the first feature, the case law, and then the second is Whitlam. Can I just draw attention to some features of the Whitlam case which perhaps weren't emphasised yesterday, and I'm conscious the court has read it. It's in the A3 at tab 40. Interestingly, the Mr. Whitlam here is Gough Whitlam's son.
I wondered about that.
Also, the Gleeson, who was counsel for Mr. Whitlam, in case the court was wondering, is not the Gleeson that went on to become the Chief Justice.
No, but I wondered whether he was his son as well.
I don't think there's any relation.
Oh, really?
I remember doing some research into that at some point.
As we say, nothing turns on the point.
It's nice to know these things.
So if one is there at starting at page 884, one sees para 26.
So sorry, which one was it?
A3. Tab 40, first one. So if one goes to 884, as Mr. Toomey said, the claim was put on the basis of an express as well as the implied indemnity, and I appreciate the court isn't really troubled by the express indemnity. However, it is perhaps interesting to note that in the express indemnity on 884 at 1.1, we see the indemnity was against all liabilities.
Which is a defined term.
Which is then defined at the bottom of 887 as meaning any loss, liability, cost, charge, or expense. If one then goes to 893, from paras 50 to 52, we can see that Mr. Whitlam was claiming an indemnity in relation to damage to his reputation and consequential loss of earning capacity. See that in para 50.
Hang on 1 second. Yep.
And that remained a live issue on this appeal. We see that at the end of para 51. And the claim was that was the type of loss that fell within the indemnity as well as legal costs. And the court, in dealing with that claim at para 65 on page 896, held at the end of that paragraph, the words liability, cost, charge, or expense have a common characteristic in that they all relate to a payment actually made or a payment or other incurring of a detriment that the person in question sustains as a matter of legal obligation. In my view, the word loss in the definition of liability is to be construed as having a similar shade of meaning, and then it doesn't include a loss of reputation. One sees, interestingly, an argument for Mr. Gleeson at paragraph 73 on page 9.
For Mr. Whitlam.
Mr. Whitlam, 897. The last sentence, the whole point of the indemnity he submits is to protect the officers from suffering personal loss as a result of the performance of their professional responsibilities. One sees echoes, perhaps, of the way in which it's put here. And then at para 74, there's an interesting reference to some sections from Halsbury, which I think we've not seen before, which effectively say that the holder of an indemnity is entitled to recover under the indemnity the costs of legal proceedings properly incurred in relation to the matter which is also subject to the indemnity. That remains the text of Halsbury, obviously in a different volume and edition today.
They say in that paragraph, there's all the difference in the world between the president of a company being sued as a defendant for defamation of something he does in the course of his duties, something he says in the course of his duties. Of course he has to be indemnified, but it's another thing to say that company should have to pay for him personally being a defamation plaintiff.
Yes, indeed, my lord, and that was a distinction drawn in the Whitlam case, which informed its conclusion that Mr. Whitlam was not acting as an officer in commencing defamation proceedings, and therefore his costs of doing so were not covered by the indemnity. And your lordship may recall both the Deputy Judge and Mr. Justice Freedman raised a question as to whether the decision in Whitlam was consistent with other English cases like Famatina. It seems to us that that is the key point of distinction. In Famatina, the employee had his costs paid when he was sued in defamation for what he'd done. That's different from what happened in Mr. Whitlam's case, which is why the decisions in the two cases are different. But none of that is really important for when we get to the paragraph 94 reasoning, but it's all by way of background. So it's at 83 that the court, para 83, the court turns to the indemnity under the general law, an indemnity for costs. And we see the submission of Mr. Gleeson at 84. There's consideration of Sheffield and Barclay at 85. At 87 is a passage from Bousted, and then Famatina is considered at 89, and then Mr. Gleeson's argument at 93, and then the important reasoning, which we say is correct, and the judge was correct to adopt the reasoning at 94. Before we leave it, it may be worth noting also that 97 to 98, Campbell JA, with whom the other members of the court agreed, goes on to consider the tests for implication of a term in the contract. And he applies the vicious bystander test at 98 and effectively says, well, the employer and employee might give different answers to the question as to whether the indemnity is to cover a particular type of loss. And then the indemnity in law test is referred to at 99, which the judge says he's already considered earlier. I just wanted to draw attention to some of those other features of the Whitlam judgment. The judge, of course, adopted the reasoning in 94 and elaborated on it in his own words in paras 327 to 30 of the judgment. If I could ask the court to go back to that. And it's at 327 that he explains why, if the indemnity is correct as contended for by the appellant, the law books in relation to the existence of duty of care would have to be rewritten, because the indemnity would eclipse the learning on the law of it.
That wouldn't be the first time in legal history that happened, because Hedley, Byrne and Heller rendered effectively otiose the previous case law on fraudulent misrepresentation. And many hundreds of years ago, the writ of absentia completely bypassed the statute of frauds, which required a seal before you could sue on a promise. That's why we created the doctrine of consideration. So these things can, sometimes quite radical things, can happen in the common law.
Yeah.
There's always a first time.
Yes.
Otherwise, the common law would never have developed.
Yes.
Why is it in the present context that we shouldn't take the first step?
Well, my Lord, because the Supreme Court has recently explained that the correct approach in a novel duty of care case is an incremental approach.
Yes, but I think what my Lord is suggesting is this is the next increment.
Well, our response to that is this would not be an increment, this would be a big leap. And your Lordships have seen in the authorities, I think that this language started with Lord Justice Dyson in the Crossley case, that the court, he was saying this court, the Court of Appeal, should not make a big leap to introduce a major extension in the common law. Could I perhaps just look that up as I refer to it in response to my Lord's question? It's in A2 at tab 37.
Sorry, which tab?
37. This was the case of the employee who applied for early retirement on medical grounds. There was an insurance policy to pay his wages provided he remained in employment, and because he resigned his employment, he lost the payment from the insurers. And he said, well, you, my employers, had a duty to look after my economic welfare. You should have advised me not to resign, because I would then suffer a financial loss. And the courts said, well, there's no standard obligation implied in contracts of employment requiring an employer to take reasonable care for the economic well-being of the employee. And it's paragraph 42 that I had in mind a moment ago, where Lord Justice Dyson, having considered Mallock and Scally and Spring, says two reasons why the implied term should be rejected. First, it's not for this court to take a big leap to introduce a major extension of the law in this area, when only comparatively recently the House of Lords has declined to do so. And as we might see if there's time to look at authorities on duty of care, in Robinson in particular, and also James Bowen, that language is adopted, that what the courts must do now is, where there's a novel duty proposed, look at the analogous authorities, the significant legal features in those cases, and decide whether this is an appropriate case to make an incremental, i.e. small step development, not big step. And we say this would be a big step, because it would, at a stroke, effectively render the law of negligence otiose in terms of employer liability, because the employee could simply claim under the indemnity. So it would not be a small step increment, it would be a major extension of the common law, which would be contrary to the incrementalism that's now required.
And I think in support of that, you would point out, obviously there are many good reasons why the law takes that approach, but one of them is the settled expectations of people in the business community, for example.
Yes, Lord, I respectfully agree, the need for certainty. And in the context of employer liability, of course, there are policy implications as well, particularly as to what liability employers should bear. And if a major change is made, it's often said that should not be a change made by the courts, common law. But if they are major with those policy implications, they should be made by Parliament.
This does rather go round in a circle, because you say it's a big leap. Mr. Toomey says it's an incremental step. You say nobody's ever brought a claim like this before and hasn't succeeded. Mr. Toomey says, well, that's because there's a very special set of facts in this case. The Armageddon argument only gets you so far.
Well, there's an important distinction, we say, between indemnity in law and indemnity in fact. Indemnity in law is a term implied into all contracts of the particular category before the courts. And therefore, we do say if the indemnity in law were correct, it would apply not just in Mr. Benyatov's contract, but in all, we'd say, all employment contracts. And that's why it's a major increment. If one wants to say, well, just look at the facts of this case, this is where the indemnity should apply, then one's in the territory of indemnity implied in fact. And that's when we go to, well, what are the facts in this case and what are the judge's findings of fact? But that's why we say to imply the indemnity in law would be a major step. And as certainly the judge says in this case, it would be remarkable if this indemnity existed, that nobody had advanced a claim or raised it in these very many claims brought by employees for loss of earnings against employers, particularly where the employees have failed. And as you know, the judge gives two examples of cases where he says the decision would be different and they could be multiplied. And there's time I'll mention one or two others that would be very different. And that's, in fact, where I was going to go next, 328 and 329, where the judge mentions Reed and Russian-Tompkins and Greenway and Johnson-Matthey. We had some debate yesterday about Reed and Russian-Tompkins, and in our submission, there's no basis for distinguishing that case on the basis that, well, it was the occasion for the loss as opposed to the cause of the loss. Mr. Reed was in his collision when he was going about doing his job in the proper way. If the indemnity applied, he could have recovered for his loss of earnings, we say in that case. Greenway and Johnson-Matthey, you'll remember, I'm not sure that we've looked at it, it's for your Court's Note A3 at tab 51, is the sensitization to platinum salts. Employees who became sensitized to platinum salts then were moved from their jobs for health reasons, and when they left couldn't get jobs in the same sort of walk of life subsequently. Up to the Court of Appeal, there was no physical injury thought to have been suffered, so it was a claim only for economic loss, which failed. And there's a very illuminating judgment from Lord Justice Sales, as he then was, which may I encourage the Court to look at it and to read that, because he emphasises the limitations on actions there for recovery of economic loss in the employment relationship. Now, we say if and the claim failed, and just for completeness, went to the Supreme Court, and the Supreme Court decided actually there was physical injury, so it wasn't only an economic loss claim, but Lord Justice Sales, the Court of Appeal's approach to economic loss still stands. And we say, well, that would have been different, because here were employees simply doing their job, as a result of which they are sensitized to platinum salts. They suffer loss of earnings. They sought to establish a duty of care on the part of their employer to protect them from that economic loss. They failed. The indemnity existed. It was a loss which arose in or as a consequence of them performing their duties. The employer should have been liable under the indemnity. Whilst we're in Greenway, could I just also draw the Court's attention to the end of Lord Justice Sales' judgment, which is at paragraph 55, I think it's page 1273 of the bundle. where he says, in the last sentence, the law does not furnish a remedy for every harm suffered by an individual, and in particular does not do so where the infliction of the harm in question doesn't constitute a wrong in the contemplation of the law. It's an uncontentious proposition, but perhaps in response to my Lord's question, or Justice Underhill's question to me before the short adjournment, as to whether one can understand this from Mr. Benyatov's point of view, and the bank agrees it's an unfortunate situation he's in, but it doesn't mean that for every harm in question, there's a remedy provided. Now, we say it's no answer to the reasoning in Whitlam as adopted by Mr. Justice Freedman to say, as Mr. Toomey now seeks to say, well, the indemnity is limited. It only applies where the performance of the duties is a direct cause of, rather than the occasion for the loss. And it only applies where there is a third-party interaction. We make the following points about those suggested limitations. Firstly, the appellant's pleaded case is not subject to any limitation as to third-party interaction. We saw the indemnity, which is pleaded at paragraph 19.1 of the APOC. It's an indemnity in respect of all losses suffered arising from or in consequence of performing his duties. It's not pleaded as one that arises where there is a third-party interaction, which is a limitation that Mr. Toomey has sought now to introduce. And we say, well, the court's task is to adjudicate on the pleaded case in its broader, unqualified terms, as opposed to the constantly evolving case. Second, we say the distinction sought to be drawn between a loss that's directly caused by the performance of the duties, or is only a loss where the performance of the duties was the occasion for it, is in many cases a distinction without a difference. It would be in many cases impossible to draw and unworkable in practice. It would involve dancing on the head of a pin. In Reed's case, why was his driving the occasion for the loss rather than his loss arising from the performance of his duties? In the present case, why is the loss any more directly caused by Mr. Benyatov's performance of his duties than was the loss in Reed and Rush and Tompkins?
Can I suggest an example of where you could readily see that it is the performance of the work that the employer requires to do? If the employee is a driver and their task is to deliver a parcel. So let's change the hypothesis I suggested yesterday. It's not that the employer directly instructs them to break the speed limit. It's just that they say, I don't really care how you get there, but you've got to get there by 3 o'clock because the customer needs his parcel at 3 o'clock, no later. And so in performing that instruction, the employee does break the speed limit. I think Mr. Toomey would say, well, that's an example of where you can readily identify that it's the very performance of the employee's duty which creates the third-party liability.
My Lord, our response is these are distinctions which are very difficult to draw in practice. And whatever might be the merits, if any, of these distinctions between direct cause or occasions for, as a matter of the law of causation, what we're concerned with here is a term implied into a contract of employment. And we know that a term to be implied has to be capable of precise definition, and it has to be workable in practice, and it has to be understood by employers and employees. We wouldn't be concerned here with a court in an ex post facto situation analysing to see whether there was a direct cause or an occasion for This is about how employers and employees ex ante are to conduct themselves, and therefore any implied term has to be really clear, comprehensible to people in the workplace, because they will adjust their conduct accordingly and workable in practice. And we say it simply wouldn't if one is having to sit and analyse in the way we have been doing in the last day or so, whether it falls one side of the line or the other. But there's no good reason being given in our submission, this is a further point, as to why the indemnity should be limited to the case where there's a third-party interaction. What's the reason in principle why it should be available in that case, but not in a case where there's no third-party interaction? There's no reason of principle, we say, for introducing that limitation. Rather, what seems to happen is that the appellant's case evolves and changes in a way so as to bring themselves within the indemnity, but without any rationale for introducing these limitations. If the limitation is to apply, how is it to be defined? What form of third-party interaction would suffice? Does there have to be direct contact with the third party? Would something indirect suffice? Must the third party be solely responsible for causing the loss, or partly responsible? These are questions which remain unanswered and are not capable of clear expression to satisfy the requirements for an implied term. Lord, if one considers the example of James Bowen as another example, your lordships will recall that was the case where police officers were accused of assaulting a suspected terrorist when arresting him. The terrorist brought a claim against the Metropolitan Police Commissioner as vicariously liable for the officer's assault. The claim was settled, and the officers brought proceedings against the Commissioner, alleging a breach of duty of care to protect their reputation in settling those proceedings. The claim failed for lack of a duty of care. If the indemnity applied, why would the indemnity not have sufficed to enable the officers to recover from the commissioners? It was precisely their carrying out of their duties in arresting the suspect which gave rise to legal proceedings brought by that suspect, the outcome of which the officers claimed caused them loss. How is that different in any material respect from Mr. Benyatov's situation, where he says it was the performance of his duties which led to the proceedings being commenced, the outcome of which has caused him loss?
Sorry, what was the reference to that case?
Well, it's James Bowen. It's at A4, tab 56. I was going to come to it in the context of duty of care as well, but perhaps one could just turn it up. So A4, tab 56. Lord, I can perhaps just ask the court to look at the head note at this stage, which I think makes good the point I'm seeking to make.
Yes.
So, my lords, we say that's another example where if the indemnity applied, it would have availed those officers of a remedy. They could have said, well, because of the actual doing of our job, carrying out an assault, proceedings have been commenced, our economic interests have been damaged, we don't have to establish a duty of care, we'll simply claim under the indemnity. And those cases we've looked at, Reed, Greenway, James Bowen, are examples of financial loss, but the indemnity would of course apply in cases of physical injury as well in the workplace, where the indemnity would avail an employee. If an employee suffers physical injury in the workplace, they wouldn't have to prove negligence against the employer. They would be able to sue under the indemnity for losses suffered arising from or in consequence of the performance of their duties. So all those cases where employees have suffered physical injury and have failed in their claims because there was no negligence by the employer, or sometimes no duty of care owed, could have claimed under the indemnity. So, my Lord, I've dealt with the step 2 of the judge's approach to the indemnity, which was looking at the case law and then the Whitlam reasoning, those two powerful features, as he put it. And the judge concluded the indemnity isn't as broad as contended for. Step 3 is where the judge went on to consider whether the indemnity ought to be extended. So at paragraph 330 of the judgment, the judge states his conclusion as to the existing indemnity, and then says, last sentence of 330, the question then arises to whether the indemnity ought to be extended in its ambit, which he then goes on to consider. And he identifies a number of reasons as to why he says it shouldn't be extended. And it's at 333 and 334 that he talks of the incremental approach which is prescribed for extending a duty of care. And he says, well, that would be completely sidestepped if the indemnity exists, because we wouldn't need to bother ourselves with an incremental duty of care. The indemnity could simply take over and provide a remedy for employees who suffer injury, whether financial or physical, in the workplace. That was his first reason why the indemnity shouldn't be extended. It would flout the incremental approach. Secondly, he says at 334, well, it would cut across many statutes about employers' liability and wouldn't be consistent with legislative policy in employers' liability statutes. And we say that is a well-founded point as well. As we know, employers' liability consists of liability in negligence or for breach of statutory duties. As the court, I'm sure, will know, before 2013, breach of statutory duties could give rise to civil liability on the part of employers. The law was changed in 2013 by the Enterprise and Regulatory Reform Act, so that breach of statutory duties will no longer give rise to civil liability on the part of employers. But if the indemnity exists and an employee is injured as a result of conduct in the workplace that could amount to a breach of statutory duty, the indemnity would impose liability on the employer in circumstances where Parliament has said civil liability shouldn't be imposed on an employer.
So I ought to know this. There's a statutory obligation for employers to be insured against liability to their employees. Does the statute identify the kinds of liability against which they must be insured? Probably would say any liability in tort. I don't know whether it would say any contractual. I don't know. Maybe it's by reference to the nature of the liability rather than the nature of the cause of action, nature of the loss rather than the nature of the cause of action. Maybe it's just personal injury cases.
That's my understanding, my Lord. I'm reluctant to answer definitively off the top of my head, but my understanding it is in relation to physical injury.
That sounds likely, doesn't it? Yeah.
And so we say the introduction of the indemnity or the recognition of the indemnity would cut across other employers' liability statutes. Given one example there, it would impose civil liability on employers who have not been negligent in circumstances where an employee has been injured, whereas Parliament decided that civil liability should not be imposed on employers unless they are negligent, by reason of that reform brought about by the Enterprise and Regulatory Reform Act. But one can see how it would cut across other statutes, other employment statutes as well. Take this as an example. In the unfair dismissal context, a major customer of an employer tells the employer that they should dismiss a particular employee because they don't like the way the employee has been carrying out their work for the customer. Case law suggests that in those circumstances, the dismissal of the employee may be fair as some other substantial reason for dismissal. If the indemnity applies, the employee can claim from the employer for financial loss as a result of the performance of their duties following an interaction with the third party. That would cut across unfair dismissal legislation, which would provide on that factual hypothesis that the employer isn't liable at all for unfair dismissal. Take another example in the employment field, discrimination.
I don't quite see how that previous example works. The employee would be seeking an indemnity against dismissal.
From the loss of earnings suffered as a result of losing their job.
But that would be capped. That would be capped on ordinary principles by the notice period.
Yes, but Lord, my point is, here on the hypothesis, the dismissal may be fair. So no liability on the part of the employer because it's a fair dismissal. If the indemnity applies, the employee could say, I've been dismissed and am now suffering loss of earnings arising out of...
But you couldn't have an indemnity that contradicted the terms of the contract, and the contract would give the employer the right to dismiss on X months' notice.
Yes, but my point is it would cut across the unfair dismissal rights in the Employment Rights Act.
Well, only if you had an indemnity claim. I'm suggesting you wouldn't have an indemnity claim because the indemnity couldn't make it you couldn't indemnify the indemnity wouldn't prevent you from being dismissed.
Well, why would the indemnity not cover the loss of earnings in the way that Mr. Benyatov seeks recovery of loss of earnings? He was fairly dismissed, and he says, following my redundancy, I have suffered loss of earnings as arising out of the performance of my duties, which gave rise to the conviction. So in the example I put before you, the employee is dismissed because a customer says to the employer, I don't like that employee, I want you to dismiss them. It's a fair dismissal, so the employer is not liable to pay compensation for dismissal. But if the indemnity applies, the employee could say to the employer, I want to recover my lost earnings because I'm now out of a job and don't have a job, arising from or in consequence of the performance of my duties, which led the customer to instruct you to dismiss me. Take an example of an employee who is the butt of racist comments by a customer because of the way in which they perform their job. The employer is no longer liable under statute for harassment suffered by an employee at the hands of a third party. If the employee goes off sick or resigns, the employee can say to the employer, I have suffered loss as a result of or arising from the performance of my duties. You are liable to indemnify me. There's an interaction with a third party. if the indemnity applies, it would apply in that situation and cut across the provisions of the Equality Act. Take a situation where, which is not unusual in practice, a regulator, perhaps a US regulator, publishes a notice following an investigation into a company saying that the company should not employ a particular employee in a particular regulated role. The employer dismisses the employee. In those circumstances, if the indemnity applies, the employee can claim for loss of earnings under the indemnity against the employer following an interaction with a third party. These would be all of the sort of implications which would arise if the indemnity is accepted as implied in law into contracts of employment. They're all examples where there is an interaction with a third party resulting from the performance by the employee of their job and then the loss of their job and loss of earnings. So if the indemnity were to be accepted, it would have these, we say, huge ramifications in the workplace, and the judge was right to say that it would cut across employers' liability and other statutes.
Can I just go back to where the judge drew the line, where you would draw the line? You don't say that there's no indemnity in law at all, as I understand it. You accept cases such as Famartina, that if the employee has to make a payment caused by the proper performance of his duties, payment in civil litigation, payment to lawyers to defend proceedings, payment to lawyers to defend a prosecution, then assuming as we do that the employee has not done something wrong, so that the employer dissociates himself from it, there is a liability to pay under the indemnity. Suppose that the Romanians had, instead of arresting Mr. Benyatov and keep him in custody and eventually sentencing him to a long term of imprisonment, suppose instead they had fined him. Would the bank have been obliged to pay the fine?
Well, my lord, assuming that there was no fault on Mr. Benyatov's part, which is your lordship's assumption,
Yes.
then I see no reason why the fine in that situation wouldn't fall within the indemnity. But that's different for two reasons. It's not inconsistent with our case. One is simply it is a payment made and there falls within the established case law. But secondly, the claim being made here is for the loss as a result of the conviction. And I mean, let's assume, for example, there was a conviction
Yes.
followed by a fine, then it would be still a principled approach being adopted if the bank were to say, well, we pay the fine, which is a payment out that you've had to make, but we're not liable for your claim for loss of earnings as a result of the taint of the conviction.
Yes. Well, I thought you'd say that, and that seems to me clear on the authorities, that you can't distinguish payment of a fine imposed by a criminal court from payment of damages ordered by a civil court or something like that. But suppose that this claim had been brought at a much earlier stage in respect of the general damages for false imprisonment. A layman might think it very odd that if in the course of your employment you do things which lead to a foreign court imposing a fine on you, that the employer has to pay the fine, but if the foreign state or foreign court does something much nastier to you, sends you to prison, then you don't have recourse against the employer. maybe that's just where the law's got to, but it does seem rather strange.
Well, my lord, the answer might lie in whether the employer has a duty of care to not expose the employee to that situation, and there is a potential remedy in the negligence route, but that depends on establishing the elements of a negligence
yes,
claim.
Not saying that's the test for the fine. So that doesn't get rid of the anomaly which my lord has put to you.
Well, as I understand it, my lord was asking whether a layman wouldn't find this a strange outcome, i.e. that the employer might be liable to make a payment in a certain situation, or the employee has a remedy from the employer, that the employer pays the fine, but the employee doesn't have a remedy in a different situation.
Yes,
where
I think that's indeed what he was putting, but your answer, or part of your answer, was, well, the answer may be that the employer might have to pay compensation for someone being imprisoned, for example, if there had been a breach of a duty of care.
Yes.
But my lord's example was put aside any breach of duty of care, because then you can get everything in principle. But the whole point about this is the liability to pay the fine doesn't require any breach on the part of the employer of any duty of care. It's simply, this is something you had to pay in the course of doing your job for me. So I've got to reimburse you.
Yes.
But it's odd if that employer's under that liability, but not a liability to pay compensation for some non-pecuniary or pecuniary but unliquidated, much more serious loss occasioned in exactly the same way.
Well, our response to that, my lord, is that it is a principled distinction founded in the authorities, that where a payment has been made or has to be made by the employee as a result of performing their duties, then the employer will indemnify them in relation to that payment. But the indemnity in law has never gone beyond that, and to extend it in the way proposed here would go well beyond the established case law and would open up all manner of claims and alter the existing law of employers' liability in untold and significant ways, which would be unprecedented and unjustified. One of the arguments in support of Mr. Justice Freedman's conclusion is that the extended indemnity would impose huge liabilities on employers of all sizes and resources, and that's a reason for not extending it. It's not, if we go back to the language of the test, a necessary incident of the employment relationship.
The answer you gave to my lord about the fine.
About the fine.
Appears to suggest that actually you do accept that one can draw a principled distinction between things which the employee does in the performance of their duties, in which case I think you accept in principle the employer does have to indemnify the employee, for example, in respect of a fine which they incur. It does seem one can therefore draw a distinction between that and something which is unrelated to their performance of their duties. So I think, for example, if the claimant had gone to Romania on business for Credit Suisse, but while he's in Romania he commits some other offence, which has nothing to do with the performance of his job, and he's fined for that, you would say, well, the indemnity doesn't cover that, presumably. Yes,
well, but we'd say, well, that's a clear line between somebody doing their job or not doing their job, doing something entirely separate.
Exactly. So I think that the real battle line between you and Mr. Chume is not about whether you can, in principle, conceptualise that there are certain activities which are in the performance of the employee's duties and others which are not. That's not the battle line. I think the battle line is between what you accept, which is payment to a third party, or at least a liability to pay a third party, and Mr. Toomey says, no, it's not confined to that, it also includes future loss of earnings.
Lord, I accept that's the bright dividing line between us. It seemed that Mr. Toomey was then seeking to introduce another limitation on the indemnity to make it more palatable, to which our response is that's an unworkable distinction to draw. But certainly we say there is a bright dividing line. We accept there's a liability to indemnify in relation to payments made or liability to make payments arising from the performance of duties and within the scope of authority, because, without repeating myself, there's 400 years of case law to support that. There is no case law to support the extended indemnity, and the implications of the extended indemnity would be so significant as the judge has indicated.
Yeah, and only, of course, if the employee has done nothing wrong. And that, in a sense, was the issue in the James 7. In one sense, the £10 or £100 that was forfeited was something wrong, because basically the master had jumped his bail in India, but he had done it on the instructions of the master. So as between him and the master, he'd done nothing wrong. It was like my lord's example of breaking the speed limit at the express instruction. Yes. Well, now, that might be a convenient point to break, unless if you've got a minute or two more, if you just want to finish off, that's fine. But we can't go much longer.
Well, may I just finish off then? Because
yes.
I was identifying 4 steps in the reasoning of the judge for rejecting the indemnity law, and I dealt with 3 of them, which was the test, his analysis, the extended indemnity, and then the 4th step is the 19.2 indemnity, which he deals with at 345 to 358. And we say that he has correctly concluded that it's not a different indemnity from that pleaded in 19.1, but rather is the wording adopted from Lister is simply a way of delineating the circumstances in which the indemnity is not lost.
Yeah.
And we say he was correct in that analysis. Lord, I was then going to turn, perhaps tomorrow morning, to the criticisms of the judge's conclusions, but a number of those I hope I've addressed at least during discussion this afternoon. I'll certainly deal with the Sagona tomorrow morning.
Well, it sounds as though we're on track. You may even allow Mr. Toomey the original time intended for a reply, but let's see. Yes. Well, 10:30. Oh, just one other small point. There is a running transcript, I see, being provided to you, and I'm assuming the usual way it's being provided to us. It hasn't arrived to us yet, but will you ensure that happens? Oh, right. Well,
it has arrived electronically. Are they going to be hard copies?
If you would like them, my lord, they can.
I think we probably.
We've got 3 hard copies of yesterday's. If you would like them to be handed up.
Well, I don't think we want them tonight, but that's very helpful. Sorry, I hadn't realised they'd reached me.
We'll provide hard copies to them.
If we can have both, that's ideal. Thank you.